It's now 1 p.m. Geneva time, so we can launch the event. Excellencies, dear delegates, dear colleagues, it's a pleasure to welcome you today for a new session of our series in preparation of the 2025 meetings of the Conference of the Parties to the Basel, Rotterdam, and Stockholm Conventions. We look forward to welcome you in person to Geneva at the end of April. This series involves different stakeholders in order to help you dive more into the topics of the upcoming BRS COPs, and we'll conclude on 10 April with a briefing co-organized with the Secretariat of the Conventions. Today's event is co-organized by the Australian Council of Trade Unions in partnership with the Pesticide Action Network UK, IPEN, Solidar Suisse, and the Union Aid Abroad APEDA. We are joined today by leading experts to discuss how the fundamental change in the human rights landscape with the adoption of the right to a safe and healthy working environment as a fifth fundamental principle and right at work that every ILO member state is required to respect and promote is contributing to increasing the visibility of occupational health and safety victims of hazardous chemicals. The discussion will also focus on what steps need to be taken to make governments more aware of the urgent need to increase the effectiveness of the Rotterdam Convention to align its implementation with these fundamental human rights. We would like to warmly thank Liam O'Brien, Assistant Secretary of the Australian Council of Trade Unions, who has been the main architect of this event. Bernard Herold, who is a Senior Advisor for Decent Work and OSH at Solidar Suisse, will be facilitating the event. And before I hand over to him, I would like to share some housekeeping rules. Let me remind you that the documents presented, the summary, as well as a video of the event will be made available as usual on the webpage of this event. The transcript is also available in over 100 languages as indicated in the current slide. You are invited to post questions in the Q&A box. We will use them to feed the discussion after the presentations. And so with that, it's now my pleasure to turn to Mr. Herold and to give him the floor.
Thank you very much. Also, very warm welcome from my side to all of you to this Geneva Environment Network event, The Right to Know, Modernizing the Rotterdam Convention, Road to the 2025 BRS COPs. So as mentioned by Diana, my name is Bernard Herold from Solidar Suisse, and I'll just very briefly give an introduction to this event before handing to the first speaker. Workers are the first and last users of chemicals, with more than 1 billion workers worldwide exposed to hazardous substances. Tragically, each year, as a result of these exposures, more than 1 million workers usually die. In June 2022, the International Labour Conference decided to amend the ILO Declaration on Fundamental Principles and Rights at Work to include a safe and healthy working environment as a fundamental principle and right at work. This landmark decision, elevating the right to a safe and healthy working environment, means that all 187 member states of the ILO now have an obligation to respect, promote, and realize this new fundamental right. Today's event will show how this important decision is creating greater awareness of occupational victims and of hazardous chemicals and is encouraging stronger action to prevent exposures. Today's panel brings together experts in the areas of occupational safety and health, human rights and international law and the environment, along with real-life experiences of workers on the front line of hazardous chemical exposures. It will highlight not only the importance of a rights-based approach to occupational safety and health and chemicals management, but also the valuable role that the Rotterdam Convention, and in particular its PIC procedure, can play in enabling these rights, and specifically the right to know. In doing this, we will highlight not only the important role that the Convention can play in preventing hazardous exposures, but also the challenges that it is currently facing in failing to list chemicals that have met all the criteria for listing. Today we are joined by 3 experts and global leaders in chemical safety. Halska Grasik from the International Labour Organization, Dr. Marcos Orellano, the UN Special Rapporteur for Human Rights and Toxics, and finally Kay Williams, the head of the new Global Framework on Chemicals. In addition to these experts, we will present 2 case studies that highlight the devastating human cost of failing to list certain hazardous chemicals to Annex III of the Rotterdam Convention. We will hopefully provide for some time at the end for questions that can be put to the panel. So please, you provide us with your questions that you have during the webinar, and we will then try to have an interesting discussion at the end. So it's my pleasure to introduce now our first speaker, Halska Grasik from the ILO. Dr. Halska Grasik is a technical specialist on occupational safety and health at the ILO in Geneva. She manages the ILO's hazardous substances portfolio, addressing risks from toxics, chemicals, and waste across the global supply chains and industries. So over to you, Halska.
Thank you so much, Bernhard, for your introduction. And thank you very much to the organizers of this event for including the ILO here to talk about the critical area of the rights to know and why it is so important for protecting workers around the world. So first, a few words about the ILO, for those of you that are not familiar. The International Labour Organization is a specialized UN agency that is uniquely tripartite. We work with 187 member states, usually from ministries of labor all around the world, as well as workers' unions and employers' organizations. So in this way, we work in a tripartite structure to have the inputs of all world of work stakeholders, making sure that the normative action that comes out of this organization, the creation of labor standards, is validated in a tripartite way and can be immediately implemented at the world of work level. So today, let's talk about what that means for the rights to know. Okay, a little too fast. So Bernhard already gave us a bit of the perspective of where we stand in the world and why this is important that we talk about. We know that workers around the world are facing an occupational safety and health crisis when it comes to chemical hazards. Workers are exposed at much higher doses than the general population, and they're exposed for a much longer time period. This is the reason why we're so concerned about the deaths and the injuries and the diseases that workers are facing. We know that around 1 million workers lose their lives every year to chemical hazards alone. We know that this number is likely very underestimated. It's perhaps the tip of the iceberg. And we know that countless others face lifelong disability and chronic diseases. 80% of the deaths related to chemical hazards are due to diseases, are due to long-term cancers, neurodegenerative conditions, respiratory issues, long-term suffering for many workers around the world. And we know that no region is spared. All sectors and all supply chains have some kind of chemical exposures, whether we're talking about exposures in mining, in agriculture, in manufacturing, and textiles. This is an issue that covers much of the workplaces around the world, and it's something that urgent action is needed on. How is the ILO responding globally? Bernhard already presented one of the key changes in the framework for occupational safety and health worldwide, and that came in 2022 with the ILO decision to integrate the rights to a safe and healthy working environment. And what does this mean for workers around the world? And what does it mean for chemicals? It means that workers have a basic foundation for rights at the workplace. And these rights come in many different forms. It comes in the right to know, and we'll be talking about that today. This is about access to information. This is about understanding what are the chemical hazards in the workplace. But it's also about many other interrelated rights that are indivisible. This includes the right to training and education about workplace hazards. This includes the right to participate in occupational safety and health decision-making at the workplace level. And it's about the right to remove, the right for workers to withdraw themselves from dangerous conditions without the fear of any kind of retaliation. Let's get into the rights to know, the right to information, without forgetting that there is a framework of more of greater rights as well. And it's not only about the right to know, but about the right to know specifically. Workers have the rights to be informed about workplace hazards. And why is this so important for chemicals? In many cases, the exposures are invisible to the naked eye. We're talking about fibers, dusts, vapors, things that are not immediately clear for workers when they're working in different settings. So the rights to know about the specific exposures at the workplace are critical for protecting workers from having health impacts. Workers also need to have the information in order to make informed decisions. This is about taking the necessary safety precautions, about using PPE that is unique to the exposure scenario. Based on the chemicals, there will be a need for different types of personal protective equipment, whether these are just regular face masks, whether these are N95 masks, whether we're talking about half-face respirators or full-face respirators. These indications for what kind of equipment needs to be used is directly related to the hazard that is being emitted at the workplace. So having the rights to know also helps workers make informed decisions about the protective measures to use. The right to know also includes access to critical information. This is about having critical hazard identification information. Is the chemical toxic? Is it flammable? Is it reactive? What are the health effects linked to it? Acute, chronic, irritants, respiratory, all of these things. And this can be done through the provision of safety data sheets and can be done through having GHS applied in the workplace. But it's important that these hazards are communicated to the worker so that there's a clear indication of what is at risk. And very importantly, it's important that workers can participate in safety management, that workers are engaged in the kind of safety improvements that are necessary when it comes to chemical exposures. And here we need to take a look at the bigger picture. This is about protecting the individual worker, making sure that the individual worker is not harmed, that they don't incur any kind of diseases, but it's also bigger. It's about making sure that the workplace itself is safe, that all workers are safe, that there is a culture of safety and health at the workplace, and it's not only about one individual worker. Let's zoom out even further, and this is about having safe and healthy workplaces to make sure that there's no risk for things like major industrial accidents that will clearly impact the community, that will clearly impact public health at large. In this way, the right to know clearly goes beyond the four walls of a factory. It goes beyond the four walls of a textile facility. It goes beyond the four walls of any kind of manufacturing site that's using chemicals. The right to know for workers protects workers individually, but very clearly also protects the health of communities, the health of families in the neighborhood, and also of the environment at large. So this is very much interlinked to broader frameworks and not only limited to safety and health at the workplace. Now, don't take my word for it. I want to also give you a bit of a legislative and legal framework for why this exists, how it exists, and for the lawyers that are joining us to know that there are very clear provisions in international labor standards, in conventions, in recommendations that give workers the right to know, and that give this right both at the national level for workplace policy, but for a national level policy, and also at the workplace level at the enterprise undertaking. So let's first look to our Convention 155, which is a fundamental convention that was decided in the 2022 decision. This convention very clearly sets out that adequate information on measures taken by the employer need to be given to workers. So this is at the level of the undertaking. Employers are responsible for providing adequate information on OSH to workers, that there's appropriate training on occupational safety and health, and that workers are able to consult with the employer and negotiate and discuss on occupational safety and health. Now, this is also enshrined at the national level in Convention 187. So Article 3 of Convention 187 sets forth that the national policy must develop a preventative safety and health culture that includes information back and forth between the employer and the worker, but also the rights to consultation and to training. So we see in the fundamental conventions that both the national and the workplace level sets forth the concept of the right to know. The protocol to the Safety and Health Convention goes a step further. And here I really wanted to point this out today, that in recording and notification systems, so in recording and notification systems on occupational diseases, injuries, and deaths that might be related to chemical hazards, workers also have the right to know about these. So it's not only about having the right to know of chemical hazards, it's about having the right to know about cases of occupational accidents, diseases, dangerous occurrences, and suspected cases of occupational diseases as they relate to chemical hazards. Now we'll look at Convention 170. This is the ILO convention that deals specifically with chemical risks. Already in the preamble, in the very first lines of this legally binding standard, we see that it is a principle included in this convention that workers have a need for and the right to information about the chemicals they use at work, especially for this reason that I mentioned, that many of these exposures are in fact invisible. Workers have the right to know about the hazards of the chemicals that they are being exposed to. So here we see this from the very beginning in the convention. We see also throughout various articles more specific information. Article 7 deals with labeling and marking. Hazardous chemicals must be labeled in a very easily understandable way to workers so that they provide the essential information regarding the hazards they present at the workplace. We move on to Article 10 about identification. This is about workers having the rights to chemical safety data sheets, that they're made available to workers, and that employers also maintain a record of the hazardous chemicals that are used at the workplace, and that these records are accessible to all workers. Article 11 deals with the transfer of chemicals. So not only chemicals used at the workplace individually, but also when they're being moved between workplaces, between different areas, they must be labeled so that workers are clear to their hazards. Article 12 about exposure. This also relates to protocol from 2002 about the records. So this is about having records at the site about monitoring of the working environment and exposure that workers are facing, that these records are kept. This is very important for long latency period diseases. So we're talking about exposures to silica or asbestos, where exposures might happen at one point, but the actual health outcome might not happen until decades later. So employers are required to keep records of these exposures and that workers have access to them for any future cases of diseases. Article 15 here, we're talking about information and training. What I mentioned before, the fundamental right also to have not only the information about the hazards, but the training on the hazards. It's not just enough to know about the hazards. Employers should take a step further to train workers about how to read, interpret the labels and the safety data sheets, but also how to use protective equipment, how to take preventative actions to protect themselves from the hazards that they're facing. Finally, Article 18, again, there's a repetition in the convention, making sure that workers have the right to the information on the identity of the chemicals, the hazardous properties, precautionary measures, and training. So as you see in this convention, which is the most important legally binding convention for the world of work when it comes to chemicals, the right to know is thoroughly enshrined. It is mentioned in different articles, and it's also established in the recommendation and code of practice that we don't have enough time to describe today. But this is to give you the evidence that we have a very strong legally binding framework for the right to know when it comes to workers' exposures. I invite all of you to see if your countries have ratified the different conventions I mentioned today. And also the important reminder that even if the conventions have not been ratified, many national legislative frameworks have integrated these provisions to make sure that workers are protected, especially given the 2022 decision that occupational safety and health is now a fundamental and principle and right at work for all workplaces around the world. I'll stop here. I think I've given you enough information, but I'm very happy to answer questions and to discuss further with the other participants. Thank you so much.
Thank you so much, Halshka. That was a great presentation you made. And I think it's really important that you highlighted so strongly how well enshrined in international law this right to work actually is. And in this context, it's the right moment to introduce Dr. Marcos Orellana, who's going to be our next speaker and is also going to go into a human rights perspective on these issues. Dr. Marcos Orellana, Professor Orellana, is the current special rapporteur on toxics and human rights, and he's an expert in international law and the law on human rights and environment in particular. His mandate includes examining the human rights implications of exposure to hazardous substances and toxic waste. Professor Orellana has a very extensive experience working with civil society around the world on issues concerning global environmental justice. And he was the inaugural director of the Environment and Human Rights Division at Human Rights Watch. So over to you, Marcos, and a warm welcome from my side.
Thank you very much, Bernhard. Dear colleagues, distinguished delegates, my name is Marcos Orellana. I'm the United Nations Special Rapporteur on Toxics and Human Rights. This is a special procedure of the United Nations Human Rights Council that is tasked with monitoring and reporting on issues of hazardous wastes and hazardous substances as they relate to human rights. It was created in the understanding that exposure to hazardous substances and wastes can have a range of adverse implications for the effective enjoyment of human rights. This morning, I'm connecting via from New York, from the UN headquarters. I wish to first thank the organizers, co-sponsors of this program, especially the Australian Council of Trade Unions for its leadership. In the few minutes that I have with you, I wish to elaborate on the right to know, the right to information, also as it is known in international human rights law, and why it is relevant for the Rotterdam Convention and why it is that we need a strong Rotterdam Convention. And let me propose three reasons to you for why we need a strong Rotterdam Convention. First of all, the implementation of the right to a clean, healthy, and sustainable environment. We just heard from Harshka about how the International Labour Organization has recognized the right to a safe and healthy working environment as a fundamental principle and right at work, and the various standards that are applicable in that setting. More broadly, the UN General Assembly a couple of years ago in 2022 has, for the first time at the global level, affirmed and recognized the existence of the right to a clean, healthy, and sustainable environment. In doing so, it stresses the importance of multilateral environmental agreements and also the principles that are included in MEAs. And so the implementation of MEAs is key to the realization of the right to a healthy environment. So this is a first reason. The implementation of this right. A second reason is that around the world there's lack of capacity for implementation of the right to a healthy environment, but more broadly for the safe and sound management of chemicals and wastes. This is more so in developing countries, but not exclusively an issue of developing countries. In my work as special rapporteur, I, under the terms of my mandate and by invitation of governments, visit or conduct official country visits to several member states of the United Nations, and I've seen that firsthand that this issue of capacity is something that concerns not only developing countries but also industrialized countries. Lack of capacity often opens the door to undue corporate influence and even potential corporate capture, because where regulators and institutions do not have capacities, well, then industry that has information and that has the tools and resources in this area can exercise its influence. So this is a second reason that why we need a strong Rotterdam Convention, because of the lack of capacity in so many countries. And the third reason I will put forward to you today is that there's a duty of prevention of exposure to hazardous substances and wastes established in international human rights law. In order to discharge this duty, the tools available under the Rotterdam Convention and other instruments are key. Now, that shows, or one implication of this is that there is a need for a more effective Rotterdam Convention, that the tools that it provides need to be polished and strengthened so that it can actually deliver on what it articulates are shared responsibilities and the need for effective international cooperation to address the threats that are posed because of exposure to hazardous substances and wastes. With that, it takes to the natural question, well, how to strengthen the Rotterdam Convention? And this is where a human rights-based approach does come in. A rights-based approach to multilateral environmental agreements has various pieces. We've heard about the situation of workers more broadly that can be framed, and in a rights-based approach is thinking about how individuals and communities may be in vulnerable situations and should be given priority. My predecessor in the mandate has articulated a set of principles on workers' rights in the context of toxics. As an example, last year I presented to the UN General Assembly a report on gender and toxics, looking at the disproportionate impacts of chemical exposure on women and girls. As a couple examples. Another element of a human rights-based approach is to infuse the interpretation and application of the Rotterdam Convention in the light of internationally protected human rights. And I wish to elaborate a little bit more on this because here we leave categories of specific individuals or communities or set of people that may be in vulnerable situations and address society as a whole. And for example, one key human right that is relevant for the strengthening of the Rotterdam Convention is the right to science. I presented a report to the Human Rights Council on this right, the right to science in the context of hazardous substances. A couple of headlines from that is that there needs to be alignment between scientific knowledge and policy. And often we see a misalignment. This misalignment is not by chance. There are powerful forces in society that are trying to obscure and confuse and distribute disinformation in society in order to foster paralysis, maintain the status quo, because the status quo is quite profitable to certain economic interests. So human rights law requires alignment between scientific knowledge and policy so that everybody can benefit from scientific advances. What we've seen in the context of Rotterdam, the Rotterdam Convention, is a breakdown of the science policy interface, as the Conference of the Parties has been unable to heed the advice of the scientific committee that advises it. So this is something that needs to be addressed as a matter of urgency. A second right that I wish to highlight today is certainly the right to know, or also the right to information. Now, the right to information is an element of several internationally protected human rights. Now, the jurisprudence in the interface between human rights and the environment, so cases that have been heard by the UN Human Rights Committee or the European Court of Human Rights or the Inter-American Court of Human Rights or the African Court of Human Rights, they all stress how information is key to the realization and the normative content, so the duties that flow from rights such as the right to private and family life, the right to life. We've seen a recent decision by the European Court of Human Rights in this area concerning Italy and the dumping and burning of wastes in so-called Tierra dei Fuochi, so the land of fires in southern Italy. It's also key to the right to a healthy environment. This is where the Inter-American Court of Human Rights has pioneered in the justiciability of this right. A recent case involving the community of La Oroya in Peru, where the right to information stands prominent in regards to the content of the right to a healthy environment. We could also mention the right to prior and informed consent of indigenous peoples that has been affirmed in international jurisprudence. So the right to know as an element of internationally protected human rights. But third, moving forward, the right to information is also an autonomous human right, and it has been described as an enabling right because it enables action. Let me give a couple examples. The right to information as an autonomous right enables civil society organizations and others to defend human rights, especially in connection with environmental protection. This raises the importance of civic space, so-called environmental democracy. It highlights the role of organizations in connection with human rights. Secondly, it enables communities to confront risks, individuals and communities. So there's mobilization in communities to demand action from governments to make visible what is otherwise invisible, and so to bring attention, and that's how change usually takes place. It also allows individuals to take action at that level in order to confront risks. But that, I think there's a nuance that needs to be captured there. It's quite often that communities do not have the resources or the means to take action because they're in vulnerable situations. A couple examples: fence-line communities living in the proximity of polluting industries, often termed as sacrifice zones, may be living in extreme poverty and do not have resources to relocate or otherwise to take measures of protection. A similar situation in rural areas where communities may be exposed to the aerial spraying of highly hazardous pesticides, many of which are banned in their country of origin and yet allowed for production for export, which is a blatant double standard that needs to come to an end. And a third example is that as an enabling right, the right to information enables governments to confront risks. Now, this is an obligation under international human rights law. The adoption of measures to prevent exposure to hazardous substances and wastes. This obligation involves positive duties to face environmental risk. So a distillation of this notion is that in the face of environmental risk, the state is not it's not an observer, it's not a witness, it needs to be a protagonist. It has positive duties to act, to confront the risks and provide adequate protection to the population. Thing is, in order to carry out this duty, governments need the tools to do so. And that brings in, for example, pollution information portals. I presented a report on this issue to the Human Rights Council last year. Another very important tool precisely is the prior informed consent mechanism established in the Rotterdam Convention that provides governments, especially in developing countries, with the information that is needed in order to be able to assess whether a given chemical or hazardous pesticide can be allowed for international trade. There is a fourth right that I wish fourth human right that I wish to highlight today that is relevant in this area, which is in connection with the right to know, which is the right to an effective remedy. This right to an effective remedy is very closely connected to the right of access to justice. It has clear implications, for example, for clinical treatment, for doctors to be able to provide adequate treatment to patients. They need to know what they're suffering of, what their ailment is. It is also quite important for adequate reparations, integral reparations, cleanup. How do we clean up a contaminated site and so forth? So these four elements that I've mentioned, the right to an effective remedy, the right to information as autonomous right, the information as a component of other internationally protected rights, and the right to science, show the importance of the effective, how an effective Rotterdam Convention is crucial for the realization of human rights, and how a rights-based approach can strengthen it. And so with that, please allow me to conclude by pointing out that the Rotterdam Convention needs to overcome its paralysis. Most of its listed chemicals are in disuse. And so the Rotterdam Convention needs to again become relevant to our present day realities and not be relegated to the Museum of International Environmental Law. For that, it needs to be able and to enable information to developing countries, especially on hazardous chemicals, and give effect to what are shared responsibilities of exporting and importing countries engaged in international trade in hazardous chemicals and pesticides. More broadly, the Rotterdam Convention needs to be able to serve as a tool for international cooperation and implementation of the right to a clean, healthy, and sustainable environment. Thank you very much for your attention.
Thank you very much, Professor Marcos Orellana. That was great to have this complete overview in very short time over the different aspects and the different rights to information, also to effective remedy, and highlighting the importance of making the Rotterdam Convention work as intended, as it is really a very important instrument. And also your focus on the science policy interface. I think it's a very important aspect in this context. And you mentioned the point on, obscuring, you used as a term, and this sort of brings me to the next speakers, which will actually present a case study, which is sort of in this area of obscuring. But first, let me introduce them. So Philip Hazelton from AFIDA, he has worked in international development, industrial relations, and occupational health and safety for 35 years. He has been based in Southeast Asia for 18 of those years, including Vietnam, Laos, Cambodia, and previously he was the national OHS coordinator of the Australian Manufacturers Workers Union and worked for the International Labour Organization in Vietnam, also for 5 years in industrial relations. He has been working on asbestos hazard awareness and eliminating asbestos-related diseases in Asia and Australia for many years. And for most of the last 7 years, he has been coordinating the Asbestos Not Here, Not Anywhere campaign of Union Aid Abroad, AFIDA. He will also be joined then by Leo Yogapranat, who has been active in legal aid organizations, providing legal aid for more than 9 years before working for Lion Indonesia, including advocacy for workers. Leo has been the Director for Public Policy and Advocacy at Lion Indonesia since 2023. He has been responsible for advocating the dangers of asbestos in Indonesia by encouraging changes in laws and regulations related to asbestos and providing assistance for workers in the field of occupational health and safety. And the case study which the two of them will present is precisely in this area of encouraging changes of laws in Indonesia, and it relates very directly to the Rotterdam Convention. It's a very interesting case study, and I'm looking forward to hearing from both of them. So over to you, Philip. Thank you.
Thank you very much, Bernard. And while we wait for the presentation to come up, can I just say a few words? Next slide, please. So as Bernard mentioned, I represent the Global Justice Organisation of the Australian Trade Union Movement, that is United Order FIDA. And we're supporting a range of partners around Southeast Asia, Pacific, Middle East and Africa. And Australia is suffering a terrible legacy of the past use of asbestos, mostly chrysotile asbestos. Still, we see 4,000 deaths every year in our country, even though we stopped using the material more than 20 years ago. So with this legacy that we're facing in our country, the Union Movement for Australia, with support of the Australian government, international supporters as well, has sought to warn the countries still using this material, principally now in Asia, of the deadly risks. Indonesia remains one of the biggest importers of asbestos, as we'll hear shortly. One organisation we're working with closely in Indonesia is this NGO Local Initiative OSH Network, or LEON Indonesia. LEON is based in West Java and works to raise awareness on health and safety issues, and in particular asbestos hazards, protect workers and consumers in Indonesia from asbestos exposure and disease, and bring justice to the many victims. So we'll hear from Leo shortly. The work that we're doing constantly, we're told by governments, especially in the Asia region, the importance of the Rotterdam Convention in guiding them in creating and dealing with hazardous chemical legislation. The prior informed consent provisions for listed chemicals are very important. But what's happening with the convention? In the case of chrysotile asbestos, a class 1 carcinogen, responsible, as we hear from the World Health Organization, for 70% of all workplace cancers in the world, banned in 73 countries, responsible for over 200,000 deaths globally every year, recommended for listing on Rotterdam Convention for 20 years, blocked at each COP since 2006 by a small number of conflict of interest parties. This situation is made possible by the need for a total consensus among the parties before a listing is possible. I think it's a classic example of what we just heard from Marcos of the disconnect between scientific knowledge and policy. So chrysotile is blocked from listing onto the convention. But in the last 12 months, we've had witnessed in Indonesia an asbestos industry new tactic of misrepresenting the Rotterdam Convention to justify in court bringing civil legal action against consumer groups and NGOs, aiming to intimidate and punish them for trying to protect consumers, and aimed at blocking health warning labelling on asbestos containing materials. Probably a fairly classic strategic lawsuit against public participation. I think it's called a SLAP. This case study tonight and today we'll hear from Leo, examine a stark example that is unfolding for Indonesian colleagues, and particularly of the unintended consequences of non-listing of a recommended chemical on the Rotterdam Convention, that is chrysotile asbestos. Okay, let's hear from Leo on the situation they are facing. Over to you, and next slide, please.
Okay, thank you, Philip, for the introduction. First of all, as a representative of Lion Indonesia, I'm very grateful to have been invited to this event and given the opportunity to convey what is happening regarding the struggle for the right to know about the dangers of asbestos in Indonesia. So in this slide, in Indonesia, asbestos is regularly used since 1950. More than 1 million tons chrysotile asbestos imported in the last 10 years. And 95% of the chrysotile asbestos using as mixture for construction product mainly it's using on rooftop containing asbestos material. In Indonesia, at least there is 27 factory producing asbestos containing material. So the based on the data from Bureau of Statistics of Indonesia, that 13,000, at least 30,000 households using asbestos rooftop containing material. Next, please. So we can see this is the 10th province in Indonesia with the largest percentage of asbestos roofing as the main building material on 2024. We can see Jakarta as the national capital of Indonesia they got the highest percentage of using rooftop containing asbestos material. It's 54.68% people using the rooftop. Beside Jakarta, there is Bangka Belitung Island, Riau Island, Banten, West Java, Lampung, South Sumatra, East Java, West Nusa Tenggara. So there is still a lot of rooftop contain asbestos containing material using in Indonesia. Next. This is breaking down. Asbestos still widely used in Indonesian construction. Chrysotile is still legal to use with condition, but supervision of it use it's still very poor. Other types of asbestos are banned. So in Indonesia, the asbestos only still used legally is chrysotile, but chrysotile includes as a dangerous and hazardous material in the government ruling in the government ruling. So after asbestos is classified as a toxic and hazardous material product containing asbestos, including chrysotile cement roofing, do not include hazardous information label on the product sold to consumer, because the regular Ministry of Trade Regulation did not regulate about the labeling the dangerous hazardous information label on the product. So Liang Indonesia with KSM Yayasan Nota Budi or the non-governmental protection or consumer protection organization are pushing for consumer right to information on product containing asbestos. We registering a lawsuit to the Supreme Court to Supreme Court to cancel this or to revise which does not require asbestos cement roof to include information label on the danger of chrysotile asbestos. Next. So this is the chronology. Liang Indonesia and Inaban. Inaban is Indonesian Ban Asbestos Network. Conduct since 2010, conduct the campaign to eliminate asbestos related disease in Indonesia. So in 20 December 2022, 23, Liang and LPXM Yasana Budi submitted the judicial review lawsuit to the Supreme Court against the Trade Minister Regulation number 25 2021 additional sheet B number 5 that about the rooftop containing the asbestos material. In 19 March 2024, the Supreme Court granted our judicial review. So in 18 July 2024, the Indonesian Fiber Cement Association (FICMA), or they are the corporation of almost 11 or 20 factory that product the asbestos. They use asbestos material in the rooftop. They file a lawsuit to us on an unlawful act lawsuit at Central Jakarta District Court, and we will talk about it on the next slide. But yes, this is in 18 July 2024, Fiber Cement Manufacturer Association (FICMA) filed a civil lawsuit against those that won the labeling case in March. This is what Philip said before. This is the classic slap. To slap is often felt by corporation to aim to intimidate or to silence critic by burdening them with the cost of legal defense, forcing them to abandon their critic or opposition. So Figma tried to shut us down with this legal lawsuit. Next. This is the petition of unlawful as submitted by Figma on July 1994. They said on their lawsuit that the white asbestos or chrysotile is chemical as chemical language. MGS itu is a chemical matter protected. They say chrysotile asbestos is protected by the law number 10 year 2013 about approval producer upon the first basic information for secondly dangerous chemical and facet international trading or about the convention Rotterdam. So Indonesia has ratification about the convention Rotterdam on the act on the law number 10 year 2013. So they say Figma said that the asbestos chrysotile is protected by the convention Rotterdam. And they stated that the Rotterdam Convention had been held several times, in which the last time was on May 1 till 12, 2023, which was attended by more than 170 nations and resulted in the addition of Annex III or attachment. That until Rotterdam Convention ended in 2023, there was no agreement relating white asbestos or chrysotile as a dangerous material. And next, the Indonesian is one of member of Rotterdam Convention that I said before. So the Indonesia must submissive and obedient to the Act number 10 on the law number 10 year 2022 about ratification of Convention Rotterdam. So the basic of the lawsuit that the Figma stated that chrysotile was not agreed listing list in COP. Chrysotile are not listed on Rotterdam Convention. It was not agreed as dangerous material. They need to be prohibited. And Figma claimed that Supreme Court decision inconsistent with non-listing of chrysotile on Rotterdam Convention. That LPKSM Yasana Natabudi and Leon misinformed judge on the Supreme Court on chrysotile asbestos. Next. The thing that I want to speak about the lawsuit Figma state on the justification that in point 3, Figma said that they claim that 170 countries present at the Rotterdam Convention, COP 11/2023, have agreed not to list chrysotile or white asbestos as a hazardous material. Based on that, Figma needs to expand investing industry that use asbestos or white asbestos or chrysotile because the asbestos, white asbestos not ratified on Annex III in the Rotterdam Convention. And declare, they want the judge on the District Court Jakarta declare white asbestos chrysotile is harmless chemical. They sought Inaban to withdraw or demote or delete the news on Inaban website as long as the matter was about the asbestos chrysotile. Sought the defendant to apologize to national print media and television media, demand defendants to pay the plaintiff opportunity loss 1% every month from 7.986 trillion, and declare the white asbestos chrysotile is non-hazardous material. So Figma they dare to say that because the white asbestos is not listing in Annex III, so they blatantly claim that 170 countries present at the Rotterdam Convention have agreed not listing chrysotile. But it's very different with the fact we read on the Convention Rotterdam reading about the Convention Rotterdam on the next presentation. Please, next.
So, Leo, can I just ask you to try to sum up a little bit and speed up a little bit because we're running a bit short on time, and to sort of give the essence of where the case stands today?
Okay, sure. So the next, if we want to listen, okay, next. So this is our fighting in to protect worker and consumer in Indonesia regarding the danger of white asbestos. So the court case, I will reading the close statement. It will explain about the court case so far. With I will read the closing statement before I give it back to Philip. That in Indonesia, we want a landmark victory. Our Supreme Court ruled that the asbestos roof product must carry clear health and hazard label. This decision was not just a legal milestone, it was a moral reckoning, affirming that no community should be kept in the dark about the dangers of versatile asbestos. But the industry fought back. An association challenged the ruling in a district court, attempting to silence transparency and perpetuate the deadly status quo, misusing the Rotterdam Convention. But yet again, justice prevailed. The court rejected their lawsuit, upholding the people's right to know. This victory belonged to not just to Indonesia, but to all of us fighting for accountability in the shadow of asbestos-linked disease and death. Our struggle for the right of worker and consumer mirrors many other around the region and the world. For decades, the asbestos industry has operated globally with the same playbook: deny, delay, and divide, and block listing on chrysotile on the Rotterdam Convention. They misinform government about the health hazard of their product. Now they are trying to block consumer, even having basic knowledge about the hazard of the product, and are trying to silence our voice. FIGMA are appealing our recent court victory. Let's see where this goes next. The misinformation about the Rotterdam Convention they used to justify the court case was a dangerous new tactic. So far in the court, we have won an important precedent, mandating health warning label both for worker and consumer. Thanks. I'll give it to you, Philip.
Okay, and next slide to finish off, just a summary. So I think the important thing here is that the lack of prior informed consent for countries like Indonesia and direction there on regulation for this substance in particular, which is so dangerous, stands out as one of the failures of the Rotterdam Convention and the paralysis also that Marcus talked about. It's a very blatant example of the boldness of misrepresentation of the Rotterdam Convention by the asbestos industry, in fact trying to help sell their hazardous materials. So I think, yes, it's a very tragic example of misuse of the Rotterdam Convention, even as a marketing tool. But it also, of course, puts so many more consumers and workers at risk when they don't have that information that was talked about in the ILO Convention. So this legal action is brought against the consumer groups is a false approach in terms of the Rotterdam Convention. It's very cynical, and it's been quite, a big attempt to intimidate those advocating for public health. And let's see where it goes into the future. But certainly, I wholeheartedly agree. We all wholeheartedly agree with the view of Marcos expressed in terms of let's stop the paralysis of the Rotterdam Convention and reform the listing process. Thank you very much.
Thank you very much for both of you for presenting this very interesting example, a shocking example actually, of how an international convention can sort of be turned into the contrary of its original intent. At the same time, I find it interesting the example that you made, because one of the questions in the chat was actually from Ilham Aziz. It was asking, how can we encourage and hold factory owners accountable for ensuring workers' right to know about the chemicals they handle and the associated risks? And what you have achieved in Indonesia is, in a way, a response to that particular question on how can factories be held accountable by actually trying to get a legal decision which actually, from your Supreme Court, which actually says that the factory owners must inform not just the workers, but also generally who uses these materials later on, these processed materials, these roof sheets, to inform them about the risks. So I think that way of through legal channels forcing that this right to know is implemented is a very important avenue to ensuring that workers have the right to know and receive the relevant information. And as we heard before, they have a right to information. So with that, I would like to move to the next case study, which will be presented by the Pesticide Action Network. We will have on this, for this discussion, Sheila Willis from Pan UK. She's the head of the international programs at the Pesticide Action Network UK. And she is a honorary senior lecturer in the Division of Environmental Health in the School of Public Health and Family Medicine at the University of Cape Town, where she teaches parts of the postgraduate diploma in pesticide risk management. Sheila is very concerned with regulatory aspects of pesticide management, as well as understanding the negative impacts of pesticides and promoting effective agroecological alternatives. And she will be joined by Ivareja Vera Ngovi, who's a retired senior lecturer at the School of Public Health and Social Sciences at the Muhimbili University of Health and Allied Sciences in Tanzania, and fellow of the Collegium Ramazzini. She joined academia in 2007 from the Tropical Pesticides Research Institute, where she oversaw pesticide toxicology research for almost 30 years. She was also a WHO advisor and pesticide coordinator. She became head of Department of Environmental and Occupational Health at the mentioned university in 2007. And her research focuses on pesticide hazards practices, exposures, and health and environmental impact in agricultural settings in Tanzania. And the case study that they will present will be from Tanzania and, of course, related to the use of pesticides. So over to you, Sheila, and we're looking forward to your presentation.
Thanks so much, and thanks to the organisers of this important webinar. We're delighted to join you. So yes, we'll be talking about information gaps, lack of information flowing to people who need it, in line with what previous speakers have been talking about. But in this case, in the context of agricultural workers and farmers using hazardous pesticides. Next slide, please. So I'll just give a brief introduction to the situation of occupational exposure and acute pesticide poisoning before handing over to Dr. Ngawi, and then I'll come back at the end and just sort of broaden it out from Tanzania to show how it's a very widespread problem, not just confined to Tanzania. Next slide, please. So just to give you a bit of background briefly, pesticide poisoning is widely accepted as a major public health problem, particularly in low and middle income countries. And yet the scale of the problem is not well known. Estimates vary as to the number of cases of acute pesticide poisoning that happen each year, and they vary quite widely. The most recent and comprehensive study suggested that 385 million cases of acute pesticide poisoning occur each year, and that's equivalent to about 44% of farmers and farm workers. Several studies have revealed that a small minority of incidents are reported, and so national authorities tend to be quite blind to this problem because they simply don't have access to the data. In 2016, a study which Dr. Ngawi was involved in revealed that of those people reporting unintentional acute pesticide poisoning in Tanzania, only 6% had sought medical treatment. So again, the vast majority of these incidents are not reaching medical services, and so national authorities are rather blind to the problem. Even those that do reach medical services are often poorly recorded or poorly understood. So again, huge lack of information in this area. Our own studies in Nepal and Jamaica showed a similar picture. In Nepal, just 22% of farmers that said they'd been poisoned in the previous 12 months had sought help from official medical services, and only 7% in Jamaica. Next slide, please. So for that reason, because of this huge information gap, we work with partners in various countries to address this important data gap with respect to occupational pesticide poisoning, and to share the data with decision makers. So we've developed a phone app to help support this process, and so far we've collected data in several countries in Africa, Central and Southern Asia, the Caribbean, and in 11 different languages. The results from the 9 most recent surveys in 9 countries show that the average proportion of farmers and farm workers reporting incidents of unintentional acute pesticide poisoning over a 12-month period is 40%. Of course, there's huge variation within that average. And most countries suffer from inadequate post-registration surveillance, and they have significant data gaps. We believe that's one reason why it's so important that the Rotterdam Convention is able to fulfill its role as an information sharing mechanism. Because of the lack of resources in this area, it's so important for countries that have similar conditions of use are able to share information with each other. Next slide, please. Next slide. Thanks. So just to show an example of this in practice, I have a quote here from a pesticide regulator in Trinidad and Tobago, Mr. Hasmath Ali. He wrote to us to tell us that the pesticide board in Trinidad and Tobago has approved the phase out of 5 pesticides, and the main contributing factor to the decision was the data that was generated from our app that was tested through the University of West Indies. This provided important post-registration surveillance information, which we did not have before to make the decision. So it's so important that information is gathered and that it's shared with people who can use it and act on it. Next slide, please. So I have a huge amount of pleasure to introduce Dr. Vera Ngawi, who is hugely respected and an experienced authority on pesticides. As Bernard already mentioned, Dr. Ngawi has conducted extensive research into the conditions of use and impact of pesticides on the health of farmers and rural communities in Tanzania. And that includes the collaborative study that Dr. Ngawi will share today, conducted with the Tanzania Plant Health and Pesticide Authority, ourselves, and Agenda, which is a local civil society organisation in Tanzania. I'm doubly pleased to welcome Dr. Ngawi because prior to her academic career, she worked in the Pesticide Regulatory Authority, and so she sees it from both sides and has a thorough understanding of the type of data that regulators need to make informed decisions and the constraints that they face. So over to you, Dr. Ngawi. Thank you.
Next slide, please. Thank you very much, Sheila, for the nice introduction. It is a pleasure for me to be here today to present on an unintentional acute pesticide poisoning in Tanzanian cotton farming. Cotton in Tanzania is a strategic crop, which means the government puts a lot of effort in making sure that production is high and good. And it is an important crop because it directly sustains over 500,000 households who are predominantly smallholder farmers, and these are informal in our country. Unfortunately, pesticides are still perceived as key component in increasing productivity, but we don't have a legislation to control pesticide use. And the magnitude of poisoning generally is severely underreported, as we are going to see later. So we investigated in this particular case study the cotton growing communities, identified the pesticides involved along with main exposure routes and practices that lead to poisoning. Next slide, please. As Sheila mentioned, it was a collaborative project between the National Regulatory Authority, who are the Tanzania Plant Health and Pesticide Authority, and Muhimbili University of Health and Allied Sciences, as well as Agenda and Pan UK. It was a cross-sectional survey of 1,074 cotton farmers and farm workers in Simiyu region, which is the largest cotton producer in Tanzania. And we collected data using the app that was developed by Pan UK, which had a structured question. It was a structured questionnaire, and we are having self-reported health effects within 24 hours of pesticide exposure is our data. We analyze this data by putting the symptoms according to severity, having mild, moderate, or severe, and then we use the binary logistic regression to identify the risk factors of the poisoning. Next. Okay. When we look at the condition of pesticide use that causes the exposure and poisoning, we are looking at pesticide application, knowing that almost 86% of cotton farmers reported they use pesticide. They use manual backpack sprayers as a method of application. And the percentage of those who reported that they've had health impact is about 48%, which is higher than the globally estimated. And of these, some of them were severe, as we are going to see later. The protective equipment, which is most of the time encouraged by the industry to be used by farmers, is not something that is common. And we only see 28% of farmers saying they had received training on the use of PPE, which means the majority don't know. And that is explained by the fact that almost 2/3 wear ordinary non-protective clothing for spraying pesticides. They procure pesticides through extension service mostly, and these pesticides are provided in original containers because we saw the importance of label for information, but still we have 14% of the farmers not able to identify pesticides used in relation to the incident. Next, please. When we look at the pesticides that are associated with poisoning, we see that from the chart that it's a very small number of pesticides that are associated with the majority of the unintentional incidents that are reported. And here, chlorpyrifos is implicated in more than a quarter of the acute poisoning that were reported by the farmers. And the chlorpyrifos, which is in focus, was used mostly in co-formulation, but we know that it has been banned in more than 39 countries due to high toxicity to humans and the environment. And it is currently under consideration for listing under the Stockholm and Rotterdam Convention. Next, please. And when we look at the signs and symptoms that were reported for chlorpyrifos, we see that about 184 farmers and farm workers reported cases of poisoning, and 11% of these incidents were categorized as severe. This is a very high number. And we see the symptoms, mostly the nervous system effects were more pronounced, like severe headaches, abnormal skin tingling, numbness, which is expected of organophosphates, muscle weakness, tremors, and so on. We also have respiratory system effects and other effects. And although we say that it's only 6% that is reported, healthcare providers are not trained on management of poisoning. So even the recorded cases, sometimes it's very hard for the policymakers to use them to make decisions that will address the problem of poisoning in the country. Next slide. So our case for action, we say there's underreporting, having only 6% of people seeking formal medical treatment. This highlights the significant gaps in information. And this does not only appear to apply for cotton, it's also for other crops. We have high unintentional pesticide poisoning rates. We've said 48%, which is higher than the globally estimated. And this is linked to only a few pesticides. We also have economic costs, which are also not seen easily because nobody takes stock, but this impacts household income and agricultural productivity. And we know that suitable alternatives are certainly available to chlorpyrifos in cotton that have been thoroughly tested under the local condition. Like in Tanzania, we have organic cotton sector, a very advanced one in Simiyu, the same areas where we study, where they don't apply chemical pesticides. There's also a strong expertise in other countries in West Africa and Ethiopia, for example. Next slide.
Brilliant.
So
thank you. I hope that worked.
So the need for information sharing, we had a change in the legislation in our law in 2020 that removed pesticide research mandate from the regulatory authority. And like most low and middle income countries, Tanzania lacks a post-registration surveillance system, and regulators lack the data they need. So this seriously impedes their ability to take informed decisions and necessary actions to protect farmers and rural communities. So the regulator collaborated in this case study in order to address this gap. But we are relying on the Rotterdam Convention. We know the Rotterdam Convention is an important mechanism for sharing information between countries, it is particularly important that chemicals such as chlorpyrifos are added to Annex III to support information sharing and to give national authorities greater control over hazardous chemicals entering the country. So I would like to end here and hand over to Sheila to sum up our presentation. Thank you very much for your attention.
Thanks so much, Vera. Could we move to the next slide, please? Thanks. I only have a couple more slides. I just wanted to broaden out the picture. So we've seen a very serious situation in Tanzania where acute pesticide poisoning is widespread, and chlorpyrifos was highly implicated in a lot of those incidents, some of them very severe. As I said earlier, we've been collecting this kind of data in many countries for over a decade now, and we see that this situation is not unusual. Sadly, the problem of unintentional occupational pesticide problem is very widespread. And even though the range of pesticides used by farmers has varied, as we've looked in different countries and different situations, actually we've seen chlorpyrifos in particular feature across many countries in many surveys. The graph on the right, I don't know how visible it is to you, but we've sort of aggregated data from different regions, and the red part of the stack in each case relates to chlorpyrifos related incidents. The one on the far left was extraordinarily high, and that was a recent survey conducted, or it was 2021, I believe. I can barely read it myself. It was 2021, and a very large proportion of incidents among cotton farmers again was associated with chlorpyrifos. And across different countries and regions in southern and central Asia as well, chlorpyrifos has featured. So we would really urge parties to consider listing chlorpyrifos under Annex III. In all of these studies, or almost all of these studies, we've directly engaged with national regulatory authorities because we understand their need for information to make informed decisions. And that comes back to why we think the Rotterdam Convention is so important, that they need access to information in order to make good decisions on these pesticides. And in fact, none of the countries in which our studies were conducted has systems for post-registration surveillance, which is why we supported them to address that gap. And in that way, we've made an invisible problem visible, to bring that back to the theme of the COP. Next slide, please. Just to conclude, we'd be happy if you want to get in touch with us, and I wanted to acknowledge the various people who collaborated on the study in Tanzania. Both Vera and I work to bring different stakeholders together to make sure that civil society, regulators and academics talk to each other and share the information that they have. Thank you. Back to you, Bernard. Thanks very much.
Thank you very much to both of you for really highlighting in a very, well understanding way the importance of the prior informed consent mechanism, the information sharing mechanism of the convention, given the situation that you very well described of the very wide underreporting of incidents. The data shows really how severe this issue is, how widespread these problems are, in particular probably in lower middle income countries. And I think this is a good moment to bring this back again to the whole question of the right to know. These two case studies have shown how important this is, and I would like to now introduce Kay Williams, the head of the Global Framework on Chemicals, who is our next and last speaker here on the panel before we move to the discussion. So Kay has over 20 years of experience in the EU and international engagement in this area. She has experience as responsible for oversight of international negotiations and activities on chemicals and waste within the Department for Environment, Food and Rural Affairs, including UN multilateral environment agreements and frameworks such as the Basel, Stockholm, Rotterdam Conventions and the Minamata Convention, and finally the strategic approach to international chemicals management, SAICHEM, which, as you know, is the predecessor of the Global Framework of Chemicals. So she was the co-chair of the Beyond 2020 framework under the SAICHEM, and she contributed to the development of a very ambitious outcome at the International Conference on Chemicals Management in Bonn at the end of September 2023. So thanks a lot, Kay, for joining us here, and over to you to give us a bit of context and to show us how the GFC will be able to address these issues around the right to know and the importance also of the MEAs in ensuring strong governance mechanisms to protect planet and human health, and also to ensure this right to know for workers and the communities. Thank you.
Thank you very much, Bernard. And dear colleagues, thank you very much for being invited to talk a little bit more about the Global Framework on Chemicals and how it can work together with the legally binding multilateral environment agreements to really establish the right and strengthen the right to know. First of all, I'm going to give a little summary for those of you that may not be so familiar with the Global Framework on Chemicals. This was negotiated in 2023 in Bonn and is different from the strategic approach to international chemicals management because it, for the first time, puts targets in the framework which we have to try and meet. It's got 5 strategic objectives, 28 targets, and the beauty of this framework is that it is truly multi-sectoral and multi-stakeholder. So that means that we have many people with an equal voice, so governments and civil society and industry and academics all have an equal voice under the framework. The Bonn Declaration was also adopted, and this is where we had a high-level political commitment to take urgent action in the area of chemicals and waste. So we have really something to go to governments to say action must happen now. And then thirdly, there was an agreement for a Global Framework on Chemicals Fund, which currently stands at around $28 million US. And we are currently having an executive board meeting, which is looking at the first round of projects that can be funded under this particular framework. Okay, can you? A little bit about how the framework operates. I'm head of the Secretariat here in Geneva. It's hosted within UNEP, the UN Environment Programme. We have a bureau of 15 board members, which where we have representatives of civil society, health, and indeed labour, as well as regional and country representation. We are being supported technically. We have the ability to have open-ended working groups. And in fact, there will be one coming up in June between the 24th and the 27th of June this year, where we will be aiming to really progress some of the implementation, which this framework is all about. We work very closely and we'll be enhancing our national focal point structure within countries. And our vision is to have not only focal points that are sitting in the environment, but that are sitting in the ministries of labour, that are sitting in the ministries of health, as well as in the ministries of environment. And we're also very much fueled by this multi-stakeholder, multi-sectoral approach, where we do have partners both within and outside of the chemical and waste sectors. Next slide, please. So as a brief summary, the strategic objectives that we have are framed around the following 5 areas. So very much an emphasis on implementation, with strategic objective A looking at those legal frameworks and capacities, making sure they're in place. The second one here now is about data and knowledge, and this is where the right to know truly comes in. And I'm going to talk a little bit about some of the targets that also speak to the right to know. C is about the issues of concern that have been worked on under the strategic approach to international chemicals management, and also any new ones that may be identified by any particular stakeholder group. The fourth one, D, is about safer alternatives, looking at innovation. How do we work with industry to create sustainable solutions, but also work not only with industry themselves, but down that product value chain, because 95% of all products do contain chemicals, many of which are harmful. And then finally, enhanced implementation through effective resource mobilization and partnerships. And again, this is where we, under the global framework, will work very closely, not only with the chemicals and waste multilateral environment agreements, but also with the biodiversity colleagues, with climate change colleagues, with the ILO, with the health sector, with all the other, all the other agreements that are doing activity in this area that can have an impact. Next slide, please. So how can the framework support Rotterdam? So it's about the shared responsibility and the open exchange of information. We're a very transparent framework. We have an opportunity to provide the forum to exchange information and to really amplify activities that are going forward. So very much the work that we've heard today that's been happening in terms of the app that's been developed for collecting data, that's something we can amplify through our international meetings, our international conferences. We can share information and provide that forum. We also, in terms of understanding chemicals risks, again, there are targets that really try to identify the information that we need to be knowing, that we need to share, and how we can actually gain that information. And certainly working with industry, we're looking at how we can take the information and the data transparency commitment that industry have made, how we can work with them to be able to meet that commitment, to not only allow transparency, but also access to the data that they are willing to share, but often is impenetrable and not understandable because it's so complicated. Next slide, please. So in terms of the targets and bolstering the right to know, we have a number of suite of targets, and these targets that are pulled out are very much about the data ones that look about comprehensive data and information. So it's looking about talking about again along the product life cycle. Any stakeholders that generate it need to try and make these publicly accessible. We're talking about education, training, and then systems like the globally harmonized system, trying to bring these more legally binding and best practices that make a difference to the fore. So the targets are there that we can make this change. Next slide, please. So a little bit more about how this could happen. Very much the IMC participating organizations. So these are the organizations that include the Food and Agriculture Organization, WHO, OECD, and the ILO, amongst others, have been running a number of webinar series that are looking to how we can implement more effectively the global framework on chemicals. And one of the approaches that has been taken in the framework is the construction of globally identified implementation programs. And there are a couple that may be of interest that could support the Rotterdam Convention and bolster where the legally binding elements to make sure that countries can take action, even though the listing is a little bit slow under the Rotterdam, they can still take action and have the information available. So strengthening national chemicals legislation and institutional capacities. There's a webinar happening tomorrow. I recommend that you, if you can try and listen into that, that will certainly be able to take forward some of the elements that will be really useful for some countries that are struggling to understand how to really make most use of the shared knowledge within this particular community to put in place legislation. Now, one of the things that we're looking at is not only, though, about legislation such as K-REACH or TSCA or some of the traditional chemical systems, but also legislation for consumer products and legislation in other areas that can also help change the approach that is taken towards chemicals to make sure that we've got an environment that indeed gets rid of those harmful ones and encourages innovation in the sectors. So the second implementation program topic that we're also looking about is about looking at the economic and financial sectors. And I think one of the things that I'd like to point out from the case studies is that we've heard one of the reasons is about the economic sense that the governments are very interested in the economy. They want to keep production going. But in fact, it can often be a false economy in terms of the development of a country when you're getting all the health impacts. And I noticed that, yes, indeed, the sharing of things like the global burden of disease, that information potentially is a high-level indicator under the framework. And certainly we're very interested in being able to use that as a communication tool to governments to be able to inform them that there really are significant costs in not dealing with some of these chemicals appropriately. So in fact, it does make not only health sense, but it makes good business sense to take action. And one of the ways that we are also trying to shift the needle is by talking to our investors and financial sectors. So investors want to know which companies to put their money behind, and they don't really want to put their money into companies that are producing hazardous and harmful chemicals that are causing ill health, morbidity, and having an adverse impact on populations. So by requiring a degree of disclosure through financial disclosures and reporting, we're hoping to bring a new element that will then have an impact on companies to do the right thing, to invest in sustainable alternatives, and to make sure that their productions and approaches to product manufacture are sustainable in the chemical sense. Implementing legally binding MEAs, including Rotterdam Convention, is very much an important part of the suite to deliver on the targets. So we need to work with all the levers that we have available. And so making Rotterdam work effectively, including the right to know, is absolutely essential. But we can help in terms of building capacity, because it's important that we do regulate industrial chemicals and consumer goods and try and fill that gap that has been identified across the piece. I think the next slide is, thank you. I think that's it. Thank you very much, and I'm ready to answer any questions.
Thanks a lot, Kay. So I'll try to move now to the discussion. We don't have that much time left, but I did see a few questions in the chat, and I'm going to take the first one right to you, since you closed off here the panel discussion, because you just touched on the Rotterdam Convention, and one question from Tam Charita was, and of course, you're not representing the Rotterdam Convention here, but you work closely on this. And he observes that the reporting to the Rotterdam Convention, especially about the industrial chemicals, is not up to the mark by many state parties. So he's asking, how can reporting to the industrial chemicals be enhanced? And, you know, I would expand the question, how can the global framework on chemicals possibly contribute to that?
Indeed, I think about transparency and traceability of chemicals, certainly along supply chains, and making sure that the information is shared. We're trying various routes. So we're working through international standards bodies, such as the Global Reporting Initiative, the SSAB, to try and make sure that there are mechanisms and that companies know from more for a financial perspective what needs to be reported, so that that investors are able to put their money there. So by finding out and understanding down the supply chain the chemicals that they're using, because at the moment a lot of people further down the value chain just don't know the chemicals that they're using. So I think reporting, it has to be easy for people. It mustn't be too onerous, but it's absolutely essential. I think we need to work across the whole value chain to make sure that we're reporting to the right levels and encouraging that in all our frameworks.
Thanks a lot, Kay, for that. The first question that was put in the chat came from Peter Ovitian. It's a pretty difficult one. And Halfska, if you're still there, I would like to give that one to you. It goes a little bit beyond the topic here. The question was, who is best placed to pay for health insurance, the employee, for those workers, for those workers who work in high-risk environments, and what if they cannot afford the premiums? So I would maybe sort of add to the question, is there any thought given to like internalizing such health costs, through that are caused by working in highly toxic environments into health insurance, and making, the employer who is, working in or having workers work in such environments pay for such health insurance, because of course that would give an incentive to decrease the risk, since healthcare premiums would shoot up if there's a lot of cases that go that mean that the employer needs to pay for that, for the health costs. Now it's a difficult question, because of course we're aware that many of these health costs are very long-term, and in particular the case of chrysotile with these very long latency periods. Of course this wouldn't work, but in the case of pesticides it's probably a bit different, because there's much more acute poisoning cases. And so the question is there any thought around that also within the ILO to internalize these costs and make, sort of a polluter pays principle, but polluter pays health costs principle, kind of?
Thanks, Bernhard, for that question. It's a complicated one. It does go beyond the scope of our discussion in a way, but I do think that it's important to recognize the role of health insurance and the role of other entities like social protection insurance, having different kind of partners on board, so that it's not only strictly with the employer, because as you say, it is a bigger picture of having a toxic complex, right? So having a manufacturer that's producing very toxic goods, and do we have an idea like the polluter pays principle? I think it's complicated, because if we look at what's happening, if we look at the national law and practice of what is happening globally, even the most developed economies still have trouble having their health insurance recognize occupational diseases, right? Even in places like Switzerland, it's very complicated. So having that causality established between the exposure and the health outcome has not become easier over the decades that we've been working on this. It's because of long latency periods. It's because of chemical cocktails about various exposures. It's about exposures outside of the workplace as well. And so it's something that needs more attention, but I do think it's an avenue that we can work, it's something that we can continue to work on. However, I mean, there's a big caveat here, okay? Having health insurance means that you're working in a formalized workplace. There are so many exposures. I mean, we are looking at up to 80% in certain countries of exposures that are happening in the informal sector. How do we deal with the informal sector? How do we deal with the platform economy? How do we deal with different types of workers and different types of contractual arrangements that are not as straightforward as this one, right? And so this is a big challenge, is addressing those informal exposures and working with employers that are not part of a formalized system, which would include things like social protection and health insurance. So a big question. It requires a lot of different stakeholders to be working on this, but I think it's something that's valuable to work on in the future.
Yes, thank you. And of course, it applies also to large parts of the agricultural sector where, I mean, the example that we heard from Tanzania, of course, these are so also like, I mean, self-employed farmers that are not employed by anyone when they are producing that cotton usually. So that's indeed a very important aspect to that question. I'm going to hand a question to Philip. It's a very specific one, and it's by Ramcharitra Sa, asking how long will it take for versatile asbestos to be listed, which has not yet been listed to the annex, despite it meets all the requirements to be listed and has long been recommended. So how long to wait, Philip, for that to happen?
That's a very good question, and I think given the current structure of the Convention for Listing, which is a complete consensus of all parties, which I think at the moment is about 167 parties, the requirement of total consensus and the interpretation of that word means that any one country can block, and that's been the case since 2006, as I mentioned. I would hope it could be listed very soon, but in reality, without a reform of the convention's listing process, the countries that are selling it will probably try to keep blocking it until they run out for their own profit motive. So this is one of the reasons why we think it's so important that the convention is not manipulated by the very small number of parties that are having economic benefit from their activities in blocking chemicals that are recommended by the panel of the committee of scientists that recommend chemicals for listing. So we hope that the reform, process will be considered in coming COP and COPs, and so that one idea would be that instead of a total consensus, while the convention is very important to try to reach consensus on listing chemicals, but given the 20-year delay and blocking of and misuse of the convention's articles for economic gain, I think the move to what is generally a more common UN principle of 75% support where consensus is not possible would be a more logical way to go. But in terms of trying to pick the time, we hope soon, but I fear not.
Thank you, Philip, on that. And maybe a final question to Sheila. I'll read it out. It's very specific on the Rotterdam Convention. It's by Ilham Aziz and it's asking, how can countries exporting chemicals to factories in developing countries be required to provide full, transparent, and clear information on all chemical hazards, exposure reduction measures, and safe waste disposal practices? I think this last part is an interesting one also, on information on safe waste disposal practices. I'm not sure that's covered by the Rotterdam Convention. In what ways does the Rotterdam Convention support this goal, and how can its implementation strengthen the right to know and ensure safer chemical management in developing nations? So it's kind of a general questions, maybe to sum up. How does the convention really work, and what does it, provide to developing countries, or should it provide, and can it provide?
Thanks, Bernhard. I'm not sure I can answer all of those elements. Some of them stray outside of my expertise, but certainly the prior informed consent procedure is a central provision under the Rotterdam Convention, and that was designed to support low and middle income countries in particular to have greater transparency in the movement of these hazardous chemicals, of course, from producer nations to recipient ones. And that is contingent on Annex III working well, which, as we've said repeatedly today, sadly, it's being blocked by parties with conflicts of interest, frankly. So I would come back to Philip's solution, which would be to address that central problem with the functioning of the Rotterdam Convention. But if we can get some of these chemicals, such as chlorpyrifos, that are still widely used and, as we saw, widely poisoning people, into Annex III, then that will really give much more transparency to the movement of that chemical and control by recipient countries, and that's why we want to see that. In the case of disposal, that's I can say that the disposal of hazardous pesticides is a huge and global problem. We've seen thousands of tons of obsolete pesticides accumulating in various parts of the world, and it's a hideously expensive and difficult problem to address. So much better to have a transparent system that controls these chemicals before they're used, rather than wait until you've got a massive problem of disposal on your hands. I don't know if anyone else wanted to add on that, because I tend to have a fairly narrow focus on the use rather than the disposal end of the problem.
But I think you nailed that pretty well, and I think with that I'll come sort of to a close of the discussion, because we're going for almost 2 hours. So this is the moment to thank all panelists for very interesting presentations, very interesting discussions. Also, thank you also for answering the questions. I was able to place a few of the questions in the chat. Sorry for the ones that I'm not able to read out now at the end. And also thanks, of course, to the organizers and everyone involved in helping to get this set up. Maybe just as a reminder, we will also we've proposed a similar event, not as a webinar, but as a side event at the COP itself in Geneva. So once it's clear when that takes place, that will be in the program of the that the Secretariat will send out, and we will probably then have an opportunity to go deeper into some of these examples and of some of these points that we discussed here today. So with that, I would like to hand back to Diana, who will also give you a sort of an outlook on further webinars coming in the run-up to the BRS COPs. And I thank all people that watched this webinar and will watch it later on through the recording for your interest. And yes, maybe as a closing remark, just let's really hope that at least some of the chemicals up for the listing discussion at the upcoming Rotterdam Convention will receive the support from all parties present and reach the consensus so that they can be listed, so that the information flow for those pesticides and chemicals can be substantially improved. Thank you very much.
Thank you very much also to you, Bernard, for moderating this event, and to all those who were able to join us or will be later watching the video of the event. Just wanted to bring to attention the next event in this series in preparation for the BRS COPs. It's taking place tomorrow at 11 a.m. Geneva time, and we will be discussing a new guidance under the Stockholm Convention. There are a few more other sessions under this series that have also been confirmed. Some of them are on this slide, not all are here. One will be relating to human rights, and also the final briefing with the secretary will take place on the 10th of April. And I just also wanted to remember what Kay mentioned before. There's an IMC webinar taking place tomorrow that you were referred to earlier. It's taking place at 1 p.m. Geneva time, and you can find more information on our website because we also map there what's happening in international Geneva. So with that, thank you very much to all. And as always, you will find the summary of this event on the page that has been, and the link has been shared on chat. See you soon.